relatively small amount of money involved in some legal claims often makes it economically impractical for people to hire a lawyer to represent them in small claims court. In these cases, people usually have to represent themselves, and many times they just give up. This video is intended to answer some basic questions for those who choose to go it alone. To be clear, this video won't answer all the questions that might come up during a small claims lawsuit, but it can help you better understand the process and what is required. Who can file a small claims action? Anyone can file a small claims action as long as the claim doesn't exceed $5,000. In many counties, small claims matters are now electronically filed. In the near future, all counties will likely require small claims matters to be electronically filed. To determine if your county uses electronic filing, go to the Iowa Judicial Branch website. There, you will find a map showing the counties that currently require electronic filing. There, you will also find login instructions, e-filing forms, and training documents. If your county requires electronic filing, the following will apply to you. You will need to register as an e-filer and complete all of the small claims forms online. All business with the small claims court will be conducted through email and online. All motions, service of process, verification of accounts will have to be scanned and e-filed. Judgments are sent to claimant and respondent by email. If you are filing a suit in small claims court in a county that has not yet implemented electronic filing, you will need to go to your county's clerk of court's office to obtain and fill out the appropriate forms. The forms will ask for specific information needed to process your claim. Keep in mind that you will be required to prepay an $85 filing fee. Once you fill out the forms and pay the filing fee, give the documents to the clerk to be file stamped. Please note that there are different types of claims that can be filed in small claims court. The Iowa Judicial Branch website provides information on the various types of claims that can be filed. However, today we will only be discussing claims for money judgments. After you have filed your claim, whether it's electronically or in person, the small claims document titled Original Notice and Petition for Money Judgment will need to be served on the defendant. The original notice and petition for money judgment will provide the defendant information regarding your claim and the basis of your claim. It will also give the defendant information on how to respond to the lawsuit. If you are in a county that has not implemented e-filing, you will need to bring a copy for the clerk of court, a copy for yourself, and a copy for each defendant to be served. If necessary, the clerk can make copies for you. However, please keep in mind that you will likely be required to prepay 50 cents per page for the copies. Depending on the number of defendants in your matter, the copying cost can add up. If you are in a county that does not utilize e-filing and you file your small claims lawsuit by mail, in addition to sending the requisite number of copies of the original notice and petition for money judgment, please note that you will also need to enclose a self-addressed stamped envelope for all the copies to be returned to you. If you do not, the copies will not be returned. You will need to decide how to serve or notify the defendant, the person you are suing, of the claim. There are several different ways to serve the defendant. They include: you can send the defendant restricted certified mail, which needs to be issued through the clerk of court's office. This costs $10 a person. If it is returned to the clerk unclaimed, meaning that the postal carrier could not obtain a signature for proof of service, you will need to have the sheriff's office or a private process server deliver it for you. Your county sheriff can serve the defendant personally. This typically costs about $50. Contact your clerk of court for more information. Finally, you can also use a private process server. Their names and addresses can be found online or in the yellow pages. Their fees vary. The clerk of court can oftentimes provide you with a list of process servers in your area. The Iowa Courts Online website is a good resource to use when monitoring your case. Now that he or she is served, the defendant must respond. The defendant will typically appear through filing an appearance and answer within 20 or 60 days, depending on whether he or she lives in Iowa. An appearance and answer will notify the court that the defendant was properly served the lawsuit documents, and the defendant, in the appearance and answer, will typically respond to the claims in your lawsuit documents. The original notice will advise the defendants as to when and where he or she must appear. In a money judgment case, the date on the original notice is not the trial date. When the defendant files an appearance and answer on or before the appearance date, the clerk will then assign a date for the trial. If the defendant fails to respond to the original notice in a timely manner or fails to appear on the date set for trial, a judgment, known as a default judgment, will be issued by the court. The default judgment typically grants whatever relief or amount of money the plaintiff requests in his or her claim. It is, therefore, very important for a defendant to respond to the claim in a timely manner. The trial, or hearing date, is set no less than 5 days and no more than 20 days after the defendant enters their appearance, unless the court finds reason to order otherwise. If, for a legitimate reason, either party has a conflict with the trial date which cannot be resolved, they should request in writing another trial date or time and file it with the clerk's office at least 5 days prior to the current trial date. You should always show up to the designated location at least 15 minutes prior to the designated time for the trial. A magistrate judge will preside over the trial, and it typically will include the testimony of witnesses under oath and any written materials relevant to the claim or defense of the claim. Notify anyone you want to testify on your behalf of the trial date as soon as possible. It's up to you to make sure the witnesses appear at the trial. If a witness will not volunteer to come, you can obtain a subpoena from the clerk's office, which will require the witness to appear and provide testimony or risk being found in contempt. In addition to witnesses, the judge will want to see any written documents which tend to support your position. If the dispute is over a written contract of any kind, you should bring the contract with you and show it to the judge. Also, if there are claims for medical expenses or property damage, the bills showing these expenses should be assembled to be shown to the judge. If the suit is for balance owing on an account, you should bring your records of the account, receipts, and any other agreements or correspondence pertaining to the account to the trial. If the claim is from damages in an automobile collision, you should bring pictures of the damaged property and the scene of the accident. Please note that if you are in a county that requires e-filing and you have paper exhibits or photos, it would be ideal for you to scan and e-file the documents before your trial so that the court can have immediate access to the documents. Also keep in mind that the court will accept hard copies of the types of above described exhibits, but be mindful that if you seek to admit any digital items, such as photographs from a cell phone, the court cannot accept or consider these exhibits without requiring you to admit the entire cell phone, computer, iPad, or electronic device. Please download the photos to a CD, hard copy, or pre-file the documents. The trial is the time when you get the opportunity to either prove your claim against another party or defend yourself against a claim brought by someone else. When your case is called, stand and tell the judge you are present. The judge should be addressed as either Judge or Your Honor. Even though the trial will generally be conducted informally, you must show respect for the court at all times. The judge will usually ask each party and all witnesses to be sworn in. Once this is done, the judge will generally seek to find out what the dispute is about and will ask each party to tell his or her side of the story. The judge will also listen to what any of the witnesses have to say and will consider any materials the parties have to support their respective positions. The judge will normally do all of the questioning if neither party is represented by an attorney. If an attorney is present for one or both of the parties, then the attorneys may also ask questions. After the judge has heard all the evidence presented by the parties, he or she will usually decide the case while the parties are still present. However, in some cases, the judge may take the matter under consideration, which means he or she will rule at a later time. In that case, the parties will be notified of the ruling by mail. If the plaintiff wins and is entitled to a sum of money, or the defendant has admitted the claim, the judge may order the defendant to pay this money in installments if the defendant indicates that he or she is unable to pay the entire sum at once. If the defendant wants to pay the claim in installment payments, the defendant should tell the judge at the trial. A request for a payment plan will only be considered by the judge at the time of the hearing. After the hearing, it is up to the parties to make payment arrangements. For more information on actions that can be taken after the judge rules or issues a judgment, please visit the Iowa Judicial Branch website or consult an attorney using the Iowa Find a Lawyer service, which can be found at iowafindalawyer.com or on the Iowa State Bar Association website at iowabar.org. Thanks for watching.